Welcome back. You're watching our special broadcast. Now, the government has told the Bombay High Court that social media platforms can take a final call on whether or not to remove a post once flagged by the fact-check unit. Now, the government has said that even flagging a post with a disclaimer will qualify as a reasonable due diligence having been done by the company. Now, meanwhile, social media platform X has suspended the account of Dr. Syriac Abby Phillips, who operates the handle The Liver Doctor, which boasts of over 185,000 followers. The Bengaluru Civil Court issued a temporary injunction against the doctor after Himalaya Wellness filed a defamation suit alleging that Phillips made a defamatory remark against their product. Well, for more on this, I'm now joined by Advocate Bharat Chugh as well as Radhika Roy. Thank you so much for joining us, Ms. Roy, Mr. Chugh. Mr. Chugh, I'll come to you first. We have oral submissions being made by the Solicitor General. The centre is orally telling the High Court that, look, the social media companies need not worry. The way we've drafted the rules, they are not bound under our IT rules to act if the fact-check unit red flags a social media post as fake or false. The question I want to ask is the body of the IT rules, however, gives a different interpretation. This is the contention that the petitioners had raised. How do you look at this clarification being made by the centre orally before the High Court?
Right. So, Ashmit, this oral assurance or an oral statement made by the counsel in court does not give me a lot of reassurance for the simple reason that on a reading of the entire rules, this is not really borne out. Because if you look at the rules really mandate the social media companies to take off something which the government fact-checking unit believes to be false or misleading. This so-called option with the social media companies to take off content or not to take off content and to just put a disclaimer there that the government fact-checking unit believes it to be misleading is not really something that's there in the rules. And ultimately, at the end of the day, it is what the rules say, in terms of hard facts, which would be determinative of the matter, which would be the law applicable. And the law really does not depend on the statements made off the cuff while arguing a case. So a reading of the rules, does not give me a lot of hope.
Sure. Ms. Roy, let me come to you again, raising the very same question, even by the formula that has been proposed by the Solicitor General, that, look, the social media companies may not this may not act on the red flags raised by the fact-check unit. But nonetheless, even he points out that the aggrieved party, the complainant, can move the court. And there the question of Section 79 or safe harbor protection to the social media companies is raised once again. So the question I'm asking is there a fear or an apprehension on part of the petitioners? You helped draft their petition in the Bombay High Court that even under this revised formula being proposed in court, there is still something to be feared for social media companies.
Thank you, Ashmit, for having me here. So first of all, I'll just talk about Rule 3, which talks about all the content that is prohibited and cannot be published on any social media platform. And then there's Rule 7, which says that if a social media intermediary does not follow the Rule 3, then it will stand to lose its safe harbor protection, which means that it will be liable for any of the content which is there present on its platform. Now, Rule 7 categorically says that if Rule 3 is not followed and content that is explicitly prohibited is made available on the platform, despite it being in the actual knowledge of the intermediary that such content is prohibited, it will lose its safe harbor under Section 79 of the IT Act. Now, what does this mean? It means that the intermediary will be made liable for any litigation that may emanate from such content. Now, as we know that intermediaries at the end of the day are profit-driven. They are businesses, and it's but obvious that they would not want to get mired in litigation that would end up in punitive or criminal liability. They would prefer erring on the side of caution and taking down the content. So even if the Solicitor General says that, okay, fine, they have this choice to either not listen to the decision of the fact-check unit or not take down the content, it's merely an illusion of choice. And there's also a chilling effect which is there. They would rather take down the content rather than have it on the platform.
Sure. Sure, Ms. Roy. Thank you so much for that. Let me bring in the issue here, of course, of the takedown that was issued, the takedown order that was issued by a Bombay court to Twitter to take down the content, the account rather of Dr. Syriac Phillips. He operates the Twitter handle, The Liver Doc. Mr. Chugh, let me come to you. the issue of this takedown. Now, what's interesting is that this was an ex-parte injunction. No hearing granted to Dr. Phillips before his account was taken down. This was also, again, after this order was passed, we saw the lawyers for Himalaya send a legal notice to Dr. Phillips as well as to Twitter saying that if you don't take down, you'll lose Section 69 safe harbor protection. So the question I want to ask you is this a problem with the court order? Did the court not do its job well? Or is it a problem with the broader IT rules framework which provides room for such takedown orders to be issued in the first place?
Right. No, a number of problems with the order as it stands. As you rightly say, number one, at the very outset, it's an ex-parte order. So an order passed without hearing the opposite side. So Dr. Phillips, and who now believes and says that all of what he said in terms of his tweets is backed by scientific evidence, is backed by studies, was not even heard before the order was passed. Now, ex-parte injunctions or ex-parte orders are not unknown to law. Those orders can be passed, but usually those orders are passed when there is somebody's life at stake or some other reason. Now, in a case like this, where there are two narratives, where there is a company who believes that its products work well or are effective, and there is somebody who's relying on studies and on his own medical knowledge and experience is making a claim that there is something more than meets the eye, then that is a claim, that is a counter narrative that should be brought before the court. The court should have appreciated evidence, and the court indeed was required to appreciate evidence in a case like this to see where the truth lies in this case, and not pass an order behind the back of a party when there are disputed questions of fact. And that is really, settled law. And the problem with such orders is that such interim orders, and doctor hasn't had an opportunity of putting his side before the court. The problem with such interim ex-parte orders is that they amount to a verdict before trial. And also, the court, and this is very, very disconcerting. The court does not appreciate that there is also a public interest in knowing. And that public interest in knowing has also been violated by shutting him down in an ex-parte order. Matters such as this should be really matters of public opinion and not really courts of law. Also, it's a very, very disproportionate order in the sense that it could have been narrowly tailored for specific tweets and not the account per se and as a whole.
Interesting, but that's unfortunately all the time that we have. Mr. Chugh, I'd have to thank you for that. Miss Roy, thank you so much for sharing your thoughts with us. But that's all the time that we have. Two important cases that, of course, we'll be keeping an eye on. Bombay High Court on the fact-checking rules, as well as any future challenges that Dr. Phillips may issue to that takedown order. But with that, it's a wrap on this edition of News Center. More news and updates will continue right here on the other side.